Good evening. My name is Libby Mills, and I'm the Director of Restorative Justice Louisville. And I'm here to welcome you on behalf of President Ford from Spalding University. Unfortunately, she had a conflict and wasn't able to make it today. But she wanted me to convey how important she thinks these conversations are for our community, and hopes that everyone has a wonderful experience and we can continue these activities across the state. So have a wonderful evening, and we hope you have a lot of participation.
Good evening, I'm John Denton, Chief Justice of Kentucky, and I'm really pleased to be here to participate with this group and to mainly to hear and to listen. And I'm not going to take a lot of time to take up time from the important program, simply to say to the group that we have done our best, really with the guidance of Chief Judge Clayton and David Shepard from my office, to put together a discussion tonight where we want to listen. And I want you to know that this is hopefully the first of a series of these that we'll be doing across the Commonwealth, where we go into the community and listen to the community. But more than listening to the community, you have a commitment that tonight the entire Kentucky Court of Justice is leaning in to hear what you have to say, because it's so important that the court system have the confidence and the trust of the communities that we serve. And so this is all about hearing what we can do better to serve. And also to let you know that you not only have the ear of the Court of Justice, but you also have the commitment from the Kentucky Court of Justice to respond in every way that we can possibly respond, practically respond, to adjust ourselves to the needs of the community. So I'm really pleased that you're here. I thank you for making the effort to be here, and welcome.
Okay. Well, thank you again. Welcome, and thank you so much for coming. I just want to first, again, in addition to acknowledging you, to acknowledge the members of the Planning Committee who helped to organize this and put this on. So, any members of the Planning Committee, if you're here, please stand up. And that means you pay the bell. Here is to, as Chief Justice indicated, to have the whole justice system pretty much here before you today, and you have an opportunity to listen, to see what each organization or entity does, as well as have a chance to ask questions. We are fortunate tonight to have as our moderator Jean West, who, as many of you know, from her television work and her now currently hosting the local version of All Things Considered. So we certainly appreciate Jean doing this for us. And this time I turn the program over to her.
Thank you, Judge and Justice. And thank you all for coming tonight. So I'm going to lay out the rules a little bit. We have broken up the speakers into groups, 4 groups. Each speaker will kind of introduce themselves and give you an idea of what they and their agency does. And you will have 5 minutes, and I'm going to be the timekeeper. So this is how it's going to work. When you get close to like 4 minutes, I'm going to be sitting over there. I'm going to stand up. So in the corner of your eye, you'll see me stand up, and you'll know that you have a minute to close. If you get to 5 minutes, I'm going to come and stand right next to you very sweetly, but that means you need to wrap up. After each speaker finishes speaking, after each group finishes, then we will open it up to questions. And I believe we have some written questions, perhaps that are ready to go. We will do either written questions or there are microphones, as you can see, in the aisle. And when you approach the mic, if you would say your name And if you represent an agency or a community person who lives here, and then please ask your question and direct it to the person who can answer it, okay? So we are going to start with the first group from the Department of Pretrial Services, that's Tara Blair. The Department of Family and Juvenile Services, Rachel Bingham. The Administrative Office of the Court, and the Assistant Director of Louisville Metro Department of Corrections, Steve Durham. Steve, let's start with you.
Well, good evening. The information you have in the packet that you picked up as you came in the door tells you about Metro Department of Corrections. And part of what it tells you is that last year, for the past 4 and 5 years, 30,000 citizens have come through Metro Corrections doors. So we booked over 30,000 people a year. Metro Corrections is a big player in the justice system. There are about 600 employees in Metro Corrections. It's a large organization. So the report tells you that African Americans believe that race and financial status impacts how the people in the justice system are served. What we also know is that there's also a concern of not just about race, but about financial status of individuals, how they are impacted. So I'm going to tell you a story about injustice impacting an individual, and the purpose of telling you the story of Michael is so that you can understand how large organizations can change and impact the justice system. All right? So, but before I do that, can somebody out there tell me what time does a person get released from jail? Just make a guess. Just give me a number, an hour of the day. 1 o'clock? 2 o'clock, 2:30, 3 o'clock, 4 o'clock, 4 o'clock in the morning? The answer is yes. All those hours of the day. So people are released from jail all hours of the day. We're constantly processing individuals through the jail to move them out into the community. Well, I want to tell you about Michael. Mike was one of those individuals who came out of jail. Michael has been arrested 164 times. Michael has spent about 7 years of his life in jail, time after time. Month after month, week after week. He's what Mark Bolton, the Director of Corrections, says is an individual who is serving his life in jail on the installment plan. So here's how we process a person like Michael out of the jail. We get into their housing unit, we tell them they're being released, we pull them out, they come downstairs, they get the property they came in with, and the clothing that they were wearing when they came in, and that's the way they go out. So think about this for a second. We have a lot of Michaels. We have a lot of people, high system utilizers, who consume a lot of resources in the community, not just in jail. So Michael comes in, he gets arrested on October 1st, and it's sunny, and he's wearing shorts and a t-shirt. October 11th, 10 days later, he gets released. It's no longer sunny, it's rainy, it's cold, he's got shorts and a t-shirt, and that's what he gets released in. That's the way we used to do it. What you came in with is what you went out with. It didn't matter. It didn't matter. So what Mike would do is he would leave the exit lobby because he was homeless, he had mental health challenges, substance abuse impacted life, had nowhere to go, had no friends, and no money. So he left the exit lobby and came into the front lobby and sat down in a comfortable chair like you're in. And we say, Michael, you gotta go. He says, I'm not going. I'm not going. Michael's serious. You know, you just can't. You can't stay. You gotta go. I mean, this is not for you. This is a public lobby. You can't stay here. He'd lay down a little bit. I'm not going in. So guess what we would do? Yeah. We would arrest him for trespassing and put him back in jail. Now, it's lawful, but is it sensible justice? I don't think so. So we changed that model. We don't approach individuals like that anymore. What we have done, and this is really, we began to examine our whole process. We have taken positions inside Metro Corrections, repurposed positions. We didn't have any resource to do anything different, and it wasn't our job to do anything different. Our job is care, custody, and control. But what we did is that we hired social workers from the Kent School of Social Work. They do discharge planning, and now what we do is we get seasonally appropriate clothing for Michael. We get temporary housing for him, and not just get it and achieve it, but when he's ready and he's being released, we then drive in with his property to the temporary housing, introduce him to the person who's going to take care of him and give him housing and supportive services. And doing this has been successful. So all the Michaels we've been working with. So since 2015, when we started this, over 2,000 individuals have been served, and 40% of them have not come back in a 2-year period, not once. These high system laws have not come back. So this is an example of looking at a justice initiative and taking your challenges to listen to people and make a change to improve the delivery of justice.
Good evening. My name is Tara Blair, and I run the Pretrial Services Department for the Commonwealth of Kentucky. Kentucky Pretrial is unique. We are with the court system, and we're a statewide program. Our largest program, obviously, is here in Jefferson County. I'm real excited to be here. I like the mission of the Racial Fairness Commission and the court system. Our mission with pretrial is to give defendants access to justice. That's one of our main missions. We can't forget that when people are accused of a crime in this Commonwealth, they're presumed innocent. So during the pretrial phase, they have not been convicted of anything. So our mission as pretrial services is to provide every defendant, even the Michaels, with access to justice. Pretrial officers work 365 days a year, 24 hours a day. We interview defendants immediately when they come into the jail. In Jefferson County, our turnaround is about an hour to 2 hours. So within 2 hours of being booked into Metro Corrections, a defendant is going to come into contact with a pretrial officer. That contact with that pretrial officer is the very first contact the defendant has with the court system. Up until that point, the police arrested them, the jail booked them in. Pretrial, we are the courts. So that's the first contact the defendant has with the court system. And this is before a case is even created. Again, 24 hours a day, we're interviewing defendants. Another goal of ours is to help people. We're not just processing defendants and providing information to judges, we also try to help people. Everybody that we interview, we collect information, of course. We provide that information to the judges. Here in Jefferson County, that's 3 times a day. So every 8 hours, we are calling a judge around the clock. Our judges work very hard in this county. We're not the only ones that call them, by the way. So every 8 hours, we're calling a judge, and we're presenting defendants so that the judge can make a decision on whether or not to release that defendant. The judge has the option to release the defendant on recognizance. They can release the defendant on an unsecured bond, or they can set a financial bond that the defendant would have to pay to be released. Another one of our goals, I'll get to the helping people, is to maximize release. Release from jail pre-trial is a right. People have a right to bail. They're not convicted, and they have a right to be released. But we also have to maximize court appearance and public safety. People that are accused of a crime, they have to answer to that crime in a court of law. So we have to protect the integrity of the judicial system. So we have to maximize court appearance as well. And public safety is critical. We want to make sure that when we give information to the judge, it's objective and informative so that that judge can make that decision to release somebody or not, and making sure that the public is safe. What I've seen over the years, and I've been doing this almost 25 years, is an over-reliance on the charge. We can't forget that the charge that the defendant is accused of is just that, it's an allegation. They're not convicted of that charge. We see it in the media. When someone's charged with a serious offense and they're released, and again, they have a right to bail. Sometimes the media portrays that as that was the wrong decision. We elect our judges in this Commonwealth to make those tough decisions. And it's very important that we all uphold that. Another thing that we do to help people is we have different programs to help them succeed. We are not police. We are not advocates. You'll hear from the public advocate and the prosecutors. We are not any of that. We're neutral. But we want to help people succeed. If someone's released from jail, they are going to get a text court reminder because we want to help them get back to court. We provide that to every defendant. Not all defendants have cell phones. So we ask them, is there somebody else that has a phone that we can text that can give you that message? Because we want to help them succeed. Another program that we offer is our monitor conditional release. The judge doesn't feel comfortable just releasing somebody on recognizance, they can refer them to the monitor conditional release program. That's where our pretrial officers, they have the defendants check in with them. We try to connect them with services. If they have mental health issues or substance abuse issues, we try to connect them with those services in the community, again, to try to help them get back to court, help them stay out of trouble, and help them succeed. Recently, in October of last year, we started a pilot program called the PARTS program. This is a holistic approach where we are actually doing case management. Similar to the social work program that you heard about at the jail, we have a pretrial officer, and again, we didn't have any extra positions, we sort of just shifted things around. But that individual is actually going out into the community, finding resources for the defendants. So far, we've had about 20 people through the program. It's been a success, and it's my time's up. So if you have any questions when we're finished, feel free to ask.
Can everybody hear me? My voice projecting? Okay. All right. Excellent. So I am the Executive Officer over Family and Juvenile Services with the Administrative Office of Courts. I oversee the Court Designated Worker Program. That's a statewide program. We serve 120 counties across the Commonwealth. We are on call 24/7. I have a 2-hour response time. We work with kids at the front end of the system. Okay? So when I show this slide, I really want to emphasize that this is very specific to Jefferson County data. Pastor Palmer's in the room, and he would say this is his drop the right slide when we use this at implicit bias and cultural collision training. This is what Jefferson County looks like when you're talking about racial and ethnic disparities in the conversations that you all are having this evening. If you look at the bar that is across on the left-hand side, you'll see that the population for Black youth within Jefferson County is at 29%. For Caucasian youth, it's at 60% in the county. When we had the juvenile justice reforms back in 2014, the goal was that for all youth across Jefferson County and across the state, that they would have an opportunity to be able to have diversion and front-end services. And the goal was, if you look at the right side, for all kids to be able to have the chance at each of our contact points in the system to actually have an opportunity to have resources and supports and to actually deter future contact with the system. It's been working really well for our white youth across the state and in Jefferson County. If you look at the left side for Jefferson County, you see it is not working as effectively for our minority populations. This particular category that you see on the left-hand side is just specifically African American youth. So we have about 11% that we would consider to be non-Hispanic or Hispanic population. But what you see is at each point of contact that we have within the system, we have with Black youth a negative point of contact. So at the complaint stage, which is the door in, you can see that 62% of Black youth that come into our door have a complaint filed compared to 28% of the youth across Jefferson County. If you look at the number of overrides, you can see that it's at 69%. This could be a county attorney override or this could be a judicial override. I must say that the Jefferson County attorney who happens to be here today, Chris Brown, does an exceptional job working with us to really look at diversion eligibility, and we greatly appreciate that. We also have detection and intake for youth of color at 72%, and we have youthful offender rate at 76% for youth of color. So when we talk about disparities and we talk about disproportionality, this is the slide that stays in the front of our minds and basically haunts us within the CDW program. Go ahead, next slide, please. So in order to address these types of issues, we've been doing a lot of really proactive things within Family and Juvenile Service, and actually our Director, Roy Dudgeon, has done an exceptional job to start to grow that effort outside of just our department, and now the work is starting to happen local action planning, where they're really looking at their race data and trying to figure out how they can provide more effective opportunities for their young people, how they can refer them to individual appropriate resources, and what they need to get from the community to help support those efforts. We also have been able to provide training across the state, but in particular for here in Jefferson County, around implicit bias, cultural collision training, really trying to have staff understand what our role is as a system piece and a connection for these families, what we need to make sure that we're intentional about. One example is we had a policy around failure to appear that was actually a barrier for our families to be able to access the court-designated worker program. Within a day of staff identifying that policy issue and bringing it to my attention, we actually changed the policy statewide. And that has made our failure to appear percentage drop at a huge increase because now we're more available. The director has approved for us to go out to neighborhood places, have our meetings with our young people in their communities. That too has impacted the opportunity for our young people to actually have access to our diversion resources. And then as a state, within the department, we've been very intentional. We just finished our yearly equity assessment that all staff are requested to complete. We have an equity committee. We're looking at our policies within our department across the state. And we're very intentional to make sure that new employees and ongoing training is provided around implicit bias, what does it mean around disproportionality, and cultural collision. Thank you.
Any questions, comments for the panel? If not, we'll just power on. No question? Oh, yes, please. And if you could, again, state your name.
Hi, I'm Lee Shaw with the University of Louisville School of Law. I'm a student I have a question. First for Tara Blair. My question is, how is the Bail Project impacting pretrial services? It's been recently started here in Louisville, I think, within the past year. And how do you see that the Bail Project, with an increase in releases before trial, impact capacity requirements of detention facilities?
The Bail Project, just for those who don't know, this is a community group that posts the money amount to the court to have defendants released. And actually, the Bail Project, they don't intervene until after arraignment, because we also have an administrative release program where we can do expedited recognizance. So those people that are still in jail after they're arraigned is when the Bail Project does their screening. So we don't really work together, but we work alongside each other. So they're there after arraignment. Once the judge has already made that decision to put a money bond, then they're there to post it. And then we actually communicate with them because we don't want to duplicate services. So if it's somebody that's going to be on our MCR program or our parts program, they're not doing the case management or the supervising of those people because we don't want to duplicate it.
Two more questions. Sorry. I also have a question with regard to Ms. Bingham from the Department of Family and Juvenile Services. As the slide was that you have on there, the racial disparities really disturbing, especially here in Jefferson County. I'm concerned about what type of programs are in place and what outreach is being done between your office and JCPS to try to interrupt that preschoolerism pipeline. It was very apparent on that slide.
Great question. One of the things that we have really been working with them on, and actually we have a meeting next week, so the timing on that question is like I set you up for that. That was perfect. Basically, we're sitting down with them and we're looking at a model of doing case management very strategically between our court-designated workers and our school officials that are looking at, in particular, truancy. Everyone basically knows truancy is one of the greatest complaints across the state, but specifically here. And they have been very interested in how we can case manage together and really have the goals from the diversion aspect be connected to the school's goals. And how can that intentionality really make sure that it connects to ongoing supports the school has to offer in that community? So kids aren't looking at moving down to some other project or some other resource. They can actually get it there connected with the school. So that intentional piece, I have a really high hopes on the fact that just that communication part at the local school piece is going to be a big bridge on how we really look at kids holistically around needs Absolutely. Make sure you get my card before we leave.
Perfect, great, thank you.
Yes, my name is Jim Peterson. I'm an activist against mass incarceration. I mentor 3 inmates that are in jail or in prison. And just want to add a note for Steve Durham. He really helped me when I was able to attend a tour of the local jail with the U of L law class. And if Steve can advocate for more tours, for more people, it opens your eyes to something that I was never exposed to. And so I can see why the Bail Project is such a huge organization and such a great charity. And just want to advocate that Steve keep pushing any group that will tour that jail. It's a great thing, opens a lot of people's eyes.
Any other questions? Okay, again, the panelists are going to be hanging around after the program. If you need to speak with them individually or have any questions, they'll be happy to answer. The next group, please. From the Public Defender's Office, Leo Smith, County Attorney Michael Connell, Commonwealth Attorney Tom Wine, and Legal Aid Office, Neva Polly Scott. If we can have you all come up. And can we start, please, with the Public Defender's Office, Leo Smith.
Good evening. My name's Leo Smith. I'm with the local Public Defender's Office. Just to give you a little background, our office has been in existence for about 47 years now. We represent the microbes of the jail that Mr. Durham is speaking about. If you or someone you know is accused of a crime and actually gets charged with a crime here in Louisville, and it's in state court, not federal court, and you're too poor to hire a lawyer, then one of the 40 judges here in Louisville will more likely appoint our office to represent you. Our office, of course, doesn't charge any fees. We represent individuals of felonies, misdemeanors, and in some traffic offenses. We represent adults, juveniles. We also represent individuals who are accused of being mentally ill and someone's trying to forcibly hospitalize them. We also represent these individuals in Jefferson District Court, Jefferson Circuit Court, Kentucky Court of Appeals, Jefferson Family Court, and the Kentucky Supreme Court. I was going to tell you a lot about the Bail Project, but you've already got some of that information. So I'll fill in a little bit more about the Bail Project. The Bail Project started a year ago last May. This national organization came to town here, and we agreed to partner with it. And just to give you an idea of the impact that it's had on this community. To date, they've posted bail for close to 900 individuals. And typically the bail will range less than $5,000. Now these are individuals, if the bail had not been posted, would of course be sitting in jail, taxpayer expense. In addition to that, these individuals will probably lose their housing, possibly educational opportunities, maybe part-time employment, possibly custody of their children. And also, they very well may end up pleading guilty to a crime that they didn't commit because they are sitting in jail and they're given an opportunity to get out should they be willing to take a plea. So the Bail Project has really impacted, I think, the community here. The referral or the return rate is about the same for people who post their own bail, about a 90% return rate. In addition to that, just to give you one other figure, the Bail Project to date has posted and got returned to it over $648,000, which is then used, recycled it, posted it to bail for other individuals. So it's definitely making an impact, and I'm certainly appreciative of the fact that it's here in the community, and I appreciate it, and I'll be happy to answer any questions after the other speakers.
Good evening, my name is Michael Connell. I'm the Jefferson County Attorney, and I can look out here and see a lot of faces I'm familiar with, Reverend Lightsey and your wife. I'm glad to see you here, champion of juvenile justice and restorative justice and things of that nature. The county attorney's office is the office that most of you or anybody you know, if you ever have to come to court, that's where you're going to have your first experience. It'll be the first time you'll be in front of a judge, the first time you'll talk to a prosecutor or a defense attorney, whatever the case may be. So we are sort of the gatekeepers in that respect in the justice system. We partner with Leo and others, and Tom and representatives of other offices on trying to process matters through the court system. What happens to people when they arrive at a court is extraordinarily important. They come away with feelings, with impressions, with opinions, with anger, with satisfaction, with dissatisfaction. So it's very important as they come into the district court that the people in my office and other offices be prepared for what these people need on both sides, both victims and defendants, etc. But let's be candid. We're talking about what we do once somebody ends up in jail and the system begins. But let's be candid. The reason they got there, whether it's a juvenile court or other courts, many of these people are the result of the lack of inefficiency and the injustice that exists in our society, both culturally, racially, socioeconomically, and others. So that's who we see the majority of individuals. And what do they expect when they get to court? The booklet that you've been handed out tells you what we do as an office, and you can read that. But one thing that I've tried to instill on the criminal side of what we do, we also represent all the metro government, is a concept called procedural justice. We don't hear a lot of that talked about a lot in the community, but procedural justice is all about fair treatment and perception. Those are the two things that it deals with. And the perception, studies have shown that perception of trust increases voluntary compliance with the law. Perception of trust increases voluntary compliance with the law. Think of that for a second. The four pillars, really, of procedural justice are: one, understanding your legal rights and procedures, and understanding what you're going to face from the time you're arrested, on the street, throughout that process of the pipeline, all the way to when it's finished. The second pillar is neutrality. A feeling that the process is applied the same way, regardless of age, gender, race, or other identifying factors. So we've got understanding and neutrality. The third pillar of procedural justice is voice. Perceiving that you have the opportunity to tell your side of the story. The fourth one is respect. Treated with dignity, and that you're treated with dignity and that your rights are respected. What studies have found out is that fairness sometimes with people is more important than the outcome of their matter. That they're treated fairly and they feel like they've gotten a degree of respect, whether you're a victim or a defendant, that you're entitled to in the court system. I tell people that I hire as prosecutors, I'm not looking for anybody that wants to put notches in their gun, be a big shot, use it as a stepping stone to some other career. Our motto is we try to do the right thing. Most days we think we do, but we fail like everybody else does on a daily basis. And when we do, I want to hear about it. And it's only by that, only by our failures and our weaknesses are we going to find strength and the courage to go forth and try to do something else. But this is a system of the people that you have up here. Is that about 1 minute? This is a system of the people that you have up here, and I've seen them with these people a lot of time over the years. They're very dedicated and hardworking, but it's when that bell rings and somebody comes into that system that all of these processes and all these things begin to take place. But it's what happens way before that. Whether it's in domestic violence matters at home, and families, and dependency, neglect, abuse of these kids, those things are going to bring them to our doorstep. Eventually. The stats don't lie. So we'll just keep trudging and hope we can continue to bring a system of justice in Jefferson County that we can be proud of. Thank you.
Thank you all very much. I appreciate the opportunity to be here this evening. Mike and I kind of work hand in hand. Kentucky, like some other states, has a somewhat unusual bifurcated criminal justice system. Most people, as Mike said, will be introduced to our criminal justice system through the district court and the county attorney's office. But if it's a felony, they start there, but then they end up in the Commonwealth Attorney's Office with the circuit court. So it's important to understand that there is a process where it's a while before the case reaches the level where I prosecute. I've been with the Commonwealth Attorney's Office now. It's kind of my second stint. I served as a prosecutor back in the 80s, and then I was on the bench for about 20 years, and then came back to the Commonwealth Attorney's Office in 2013. And a lot of things have changed over those years, and some things have not changed. But it's important to understand, too, that with the criminal process, Mike will handle those cases that are referred to as misdemeanors, up to 12 months in a county jail or a fine up to $500. On our level, it's everything over 12 months. So it's 1 year up to as much as 50 years or life, or if it's a homicide case involving aggravators, it could be the death penalty. So we carry everything after that. It's important also to remember that the process, how you get into court, varies from situation to situation. Sometimes you have the arrest that Mike referred to, a police officer arrests somebody on the street. Other times there's an investigation where the officer brings in materials to our office or to the county attorney's office, and there's a complaint filed out, and even citizens can file complaints and be heard through district court or possibly, if it's a felony, through the grand jury. So when a case starts out in district court, and Mike's attorneys handle that, if it is a felony case, usually within 10 days if somebody's incarcerated, 10 days after the arrest, or 20 days if they're left out, they will have their first hearing. And at that hearing, if all goes well, there will be a decision by a judge that there's probable cause that a felony has been committed. And think about probable cause as being a 51%. More likely than not that this is the person who more likely than not committed this crime. And if the judge finds that, he or she is going to have that case then waved over to the grand jury. When we reach the grand jury, we have 12 grand jurors, citizens from the community who hear the case, and they make a decision about whether or not there is sufficient evidence to return a true bill or an indictment. Now, sufficient evidence is called a mere scintilla. So we went from probable cause at 50% down to sufficient evidence, which is a mere scintilla. But in order to get a conviction on that felony, when we appear before 12 jurors at a regular panel, we now have to have proof beyond a reasonable doubt, which nobody can define, but I'm comfortable with saying we're talking about 95% plus. So we're in a roller coaster like this. So our prosecutors have to look at those situations and decide not only can I get an indictment, I'm sure you've heard the expression, a good prosecutor can indict a ham sandwich. That was not meant as a compliment. That was meant to convey to the public that prosecutors have a tremendous amount of power. So with the least amount of information, I can get an indictment and have someone arrested and placed into jail until they're able to post bond. But that doesn't mean I'm going to prove beyond a reasonable doubt the guilt of that individual. So our prosecutors look at that as well when they make decisions. So we have 12 grand jurors who make the decision. We serve as advisors to the grand jurors. They're actually an arm of the circuit court, but we serve as advisors. Sometimes they take our advice and they follow through and they indict. Sometimes they don't. Sometimes we recommend they don't indict and they do indict. And we have to work from there. I think also what I'm proud about, the work that I do with Mike, is our heroin rocket docket. We came to the realization, the Commonwealth of Kentucky as well as local prosecutors, that a lot of people are addicted to opioids, not by choice. And because of their addiction, they're unable to function, they're unable to work, so they end up resulting in criminal activity to feed their habit. So we started a heroin rocket docket in coordination with the county attorney's office to get those people out of the criminal justice system and into treatment as quickly as possible. And we work with the local community of treatment providers to do that as well. So prosecutors, as Mike has said, it's not a matter of getting a notch on your belt or a notch on the bedpost, whatever you want to say. It's a matter of doing justice for the people who have been victimized, who have been harmed, and for people, quite frankly, who are accused of crimes. If we convict the wrong person, somebody's on the street continuing to do damage and harm. If we keep people incarcerated too long, they are more likely to end up committing more crimes because, as Mike has said, and it's been described in the Bail Project, there's a problem with staying in too long, and bonds that are solely based upon money that people can't afford is not the answer. Money does not guarantee the safety of this community. Thank you.
Good evening. My name is Neva Scott, and I serve as the Executive Director of the Legal Aid Society. First, I'd like to say thank you to all of you who came out tonight to talk about the justice system. Your feedback is always very important to us, and so I appreciate your time and your attention. And also, I'd like to say thank you for including the Legal Aid Society in this process tonight. We're glad to be here among the other agencies and service providers and proud to be part of this justice community. The Legal Aid Society, the best description I can give you for what the Legal Aid Society is that we're a nonprofit law firm. We're unique in that we serve people who live in poverty and who cannot afford to hire an attorney, but we're not appointed by the courts. A lot of times people confuse us with the Public Defender's Office, where I actually started my career as an attorney, and they think that when you go to court on any case that a judge will appoint an attorney to represent you. So that is true, as we know, in criminal cases, as Mr. Smith just described. However, that's not the truth in most civil cases, and that's not because the judges do not want to appoint attorneys or they don't believe you're deserving of attorneys. There is just not a constitutional right to have an attorney appointed at no charge to you in civil cases. There are a few exceptions to this, such as in cases where you may lose custody of your children permanently, but for the most part, there's just not that similar right in civil cases. A few examples I'll give you would be a case where you go to court and ask the court to issue a domestic violence order, to order someone who's harmed you to stay away from you. Another type of case where you wouldn't have the right to have an attorney appointed would be a divorce case. And so these are cases where members of our community are tasked with appearing in court and having to follow all the rules that are even complex for us as attorneys to know to follow all the time, and they have to appear before the court and process their case. So this is where the Legal Aid Society comes in. We were founded about 100 years ago in 1921, and we were founded because people like you in the community cared about what happened to people when they went to court, and they saw that people who lived in poverty needed a lawyer. And the courts have been a part of this process, private members of the legal profession have been part of this process, citizens who were concerned, clients who were concerned, everyone came to the table and formed the Legal Aid Society. And we're proud to continue to be part of this community 100 years later. I'm going to give you two examples of why we find that collaboration among all these entities is so important and why it enables to best serve our clients. The first I'll give to you is the Domestic Violence Advocacy Program. About 10 years ago, we saw that more often than not, a person who was a victim of domestic violence and going to court and pursuing a no-contact order was unrepresented. He or she would appear before the court and have to represent themselves. And more times than not, the person who had inflicted the harm upon them was represented. So many providers, including the courts, the clerk's office, came together and said, we need to do something about this, and the Domestic Violence Advocacy Program was born. 10 years later, we have served over thousands of clients through that program, and it's because of the collaboration. When you apply for a DBO in Jefferson County, you can also apply for a legal aid attorney at the same time at the clerk's office. And this was not because anybody thought that the victim needed additional help or a leg up in the process, but to even the playing field. Because we all know when the person is represented on both sides of the case,
There's much more likely to be the equal opportunity to pursue a fair outcome or to feel treated fairly, as Mr. O'Connell said, which is a huge, very important thing that can't be understated in our justice system. The other example that I'll give you is recently our work with expungement. You may have heard in the news that there are a lot more offenses now eligible for expungement. This is so important to our community members seeking employment. We are partnering with Goodwill, the Urban League, many other institutions to provide this service in the community. And many times we can advertise that we provide services at legal aid and hold clinics at our office and nobody shows up. But when we go out into the community to a location like Goodwill, we're able to reach the community members who weren't aware of our services, and we're able to reach out to those who really need our help. One of our mottos is that we want to meet people at their point of need, and more often than not, that's in the community. So I appreciate your time and glad to answer any questions you have.
Jefferson County, where 43% of the state's African Americans live. So what happens in Jefferson County is definitely different than a lot of other places and has a racial impact. 43% of the state's African Americans live in Jefferson County. The African American households have a poverty rate of 30% compared to 11% of the white households. White households, 225,000 white households, have an ownership rate of 70%, and African American households have an ownership rate of 36%. The reason for that was clear, deliberate, federal, local policies to promote white home ownership and underwrite it, and to exclude blacks from home ownership during the time that the federal government supported changing us from a rental to an ownership society. Why I'm bringing this up now is because any policy you have, your fines, the bonds, any policy that requires people to have wealth or an asset has a definite racial impact, and in fact perpetuates the legacy of excluding African Americans from home ownership during that 50-year period that the federal government underwrote white entry into home ownership. So every time you have a fine, every time you have a bond, anytime you have, I'll even go so far as to say the digital divide, anytime you have something that people can do online, and I remind you that Louisville is going to be closing its libraries on Saturdays and several nights a week, it has a racial impact, and you will be perpetuating and supporting that legacy of exclusion from asset building and intergenerational wealth. So I just say that at least in Jefferson County, and I am glad to hear people recognize that, anything to do with income or wealth or an asset is definitely racial and has a racial impact.
Thank you.
And I'm going to be working on evictions. I hope everybody signs up for that.
Address that issue at all? Would you, either of you want to address that issue that you brought up at all?
We use all night to talk about that.
Okay, so maybe we will tell you also, we're going to be having focus groups, sessions. Where's the judge? Right? Yeah. And I don't know if that's in your materials, but we'll talk about that afterwards so that we can continue this conversation. The focus groups conversations are going to continue. Yes, sir.
Hi, I'm Roosevelt Lights, Jr., member of the community, and I want to commend all that were involved in putting this event on. I'm glad to hear that it's going across the state. Certainly that's important. Yet I would also like to ask if those present that are presenting tonight would be willing to do this again in Jefferson County. I appreciate all that are able to be here, but I didn't find out about this event until 2 o'clock today. And my wife and I contacted over 50 people, and most of the responses we got back was too short notice. So, in the interest of collaboration, community engagement, and making sure that we have the opportunity to make these presentations before as many people as possible, I'd like to know if another event like this year is possible.
I totally agree. And that's something we can consider.
I wanted to ask the Commonwealth's attorney, has he read that book or have you heard the review of the book Charge?
John Potter just sent me a copy of that.
Okay.
And so I've not yet read it, but I thought I should read it because I sent him a copy of Michelle Anderson's book about the new Jim Crow laws, and I did read it, and I sent him a copy of that.
Okay.
So he's responding now, so I'm trying to get educated. There is another book that will kind of address the issue about disparities because of income and housing there. It's called The Color of Law.
Okay.
They talk all about redlining, and interestingly enough, when I was in college, I was doing a report on redlining. I went to a local bank, and I asked if I could see their books, and they said, "What for?" And I said, "I just want to see where you're making loans." And the first word out of that loan officer found is, "We don't redline." I said, "I didn't say you did. I was just doing this report for college. I was trying to look." So, but that was a long time ago in college. But I have not yet read it.
Well, I've only heard an interview from the author. It sounded powerful. I see that Brian Stevenson endorsed it on the back of the book. He's a very powerful man. And I think it's got a lot to say about over-sentencing, overcharging. You know, prosecutors drive the plea bargain system because we can't have everybody go to trial. We can't have 95% of people go to trial. Everybody has to plea bargain. And so it does have some solutions, and it opens up, I think, a lot of things.
All right, thank you very much. All right, thank you, panelists. If you would still hang around until afterwards, take more questions. Our next group is going to be from the clerk's office, Kevin Smalley, from District Court, Judge Haney, Circuit Court Judge Edwards, and Family Court Judge Haggerty. Judge White, there's also philanthropic redlining too, which is an interesting topic that is it's an up-and-coming discussion too about philanthropy and where the philanthropy is in communities. It's very interesting. Thank you very much. Again, can we start with Kevin Smalley?
Good evening, everybody. I want to thank you for this opportunity to be here. My name is Kevin Smalley, and I'm here on behalf of the Jefferson County Office of the Circuit Court Clerk. Mr. David Nicholson, our elected Circuit Court Clerk, could not be here this evening and wanted me to send his regards. He's at a National Association of Counties meeting this evening. Basically, the Office of the Circuit Court Clerk can be distilled to two major functions: keeper of the records of the court, as well as the processor of driver's license. Personally, we feel that this role is so important that, well, we kind of joke about it, but we take not one oath, but two oaths. As an elected circuit court clerk, Mr. Nicholson takes the constitutional oath. As the deputy clerks that work for Mr. Nicholson, similarly, we take the constitutional oath as well. But on top of that, the legislature has asked that all deputy clerks take a statutory oath as well. And that's where we swear to handle all records of the court without partiality and without bias, and without any malfeasance of office. And I think that is particularly relevant to the discussion tonight out of issues of fundamental fairness as well as racial fairness. In essence, the clerk's office is neutral. And I'm glad that we had the discussion about criminal prosecutions, but then Ms. Scott talked about the civil side of matters as well, because the circuit court clerk's office is at the crossroads of all of it. And just to throw out some general figures, Our office collected over $1.5 million of restitution and garnishments. We process over 155,000 new court cases every year. We issue almost 200,000 driver's licenses every year. We post and take over 4,000 bonds a year. And we are open 24/7, 365 days a year. And as Ms. Scott noted, that was partially because of the Domestic Violence Intake Center, as well as to take bonds at all hours of the day so that individuals do not have to be in corrections, Mr. Durham's department, any longer than they have to be. So working hand in hand with the pretrial services, the Department of Corrections, to get people in, get them out, and to have them not be in there any longer than they have to be. We have 327 deputy clerks to do this because we are moving paperwork and electronic records from 40 elected trial judges in our circuit, district, and family courts. We have 8 office locations, 3 down here at downtown, and then 5 additional driver's license locations. And the reason I wanted to give you some of this background is, we again are at the crossroads of so many things like the bail project. Normally a person would come wait in line and you're processing one bail bond at a time. Now that the bail project has come along, we would work with them hand in hand again to come in and do a bulk processing, allowing them to not have to stand in line and post one at a time, but give us a list so that we can look at these, prepare the paperwork, and get it over to corrections. We do these things neutrally. We follow the rules of the Kentucky Circuit Court Clerk's Manual, promulgated by the Supreme Court of Kentucky via the Administrative Office of the Courts. We charge fees uniformly across the state by following, again, the Kentucky Circuit Court Clerk's Accounting Manual. And I say this because, again, each county, and our county as well, are just not making up the procedures or the amounts charged or the processes that we follow. This neutrality is very important so that individuals have faith in the system. That faith that Mr. O'Connell talked about, that they are getting a fair shake, that they are getting their day in court. And we feel that that is vitally important, and we re-emphasize that with our deputy clerks as we give them that constitutional oath, as we give them that statutory oath. As we go through every new hire, we impress upon them that the paperwork that we are receiving is the most important paperwork in those individuals' lives at that point in time. Whether we're receiving it from them directly or it's information that is impacting them via a court release or a court order, it's our job to get it in, distribute it, and make sure that individuals feel like they are having their day in court. So we want to allow access, full access to the courts, and we want to live our mission, vision, and values in the clerk's office of compassion, commitment, and cooperation. So thank you.
Good evening. My name is Judge Ann Haney, and I'm the Chief District Court Judge. I'm glad to serve you, our citizens. I won't be long. This is a listening session, and I'm very excited and interested in what you all have to say. Very rarely as judges do we get the opportunity to really have a good conversation with people in our community one-on-one. We recognize that we're here to serve you, and we take that very seriously. So I'm glad that Chief Justice Minton and decided to hold these listening sessions so we can really get some true, honest feedback on how we're doing business. So thank you all for being here this evening. You all have a description of what Jefferson District Court does. I won't really go through it. I will add, however, we also do, in relation to the question earlier, we also are the jurisdiction that handles evictions. So we handle all the eviction cases in Jefferson County. As you can see, we have a lot of different subject matters that occur in Jefferson District Court. There are 17 judges, 5 days a week. There's on average 1,700 cases in Jefferson District Court per day, Monday through Friday. We run 6 night courts. We run an arraignment court. We're the only term that works every Saturday, and we work on all holidays running an arraignment court. We're real cognizant of our jail population. We're real cognizant of the fact that we try to process the cases in the most efficient manner. With the cooperation of Michael Connell's office, and Leo Smith's office, you also have to staff those offices as well as the clerk's office. Well, together, all of us through that partnership agree to work every Saturday and every holiday with the exception of Christmas Day and Thanksgiving Day. So we understand we're here to serve you all and we're here to serve our community, and we take that very seriously, and we are very honored to do so. So I'm anxious to listen. Thank you.
All right, good evening. My name is Brian Edwards. I currently serve as the Chief Judge of the Jefferson Circuit Court. First, I want to thank Chief Justice Minton and Chief Judge Clayton for the invitation to be a part of this listening session. When it comes to issues of our criminal justice system and our courts, how they intertwine with race and the perception of how our courts operate, this is something that I literally have been thinking about and involved in my entire adult life, both as a practitioner, when I was a professor, and since I've been on the court. These are topics that are near and dear to me. I'm passionate about these types of discussions, so I'm honored to get a chance to be a part of, as Judge Haney said, this listening discussion, to be a part of a discussion about these topics tonight. The description of what we do as circuit court judges is in your book. There are 13 of us here in Jefferson County. I currently am in the back year, the final year of my term as Chief Judge of the Circuit Court. We each preside over approximately 1,000 cases that are active at a time. What we do on a day-to-day basis varies. If we're in trial, then we're in trial all day. If we're not in trial, we have dockets, and the majority of our in-court time deals with criminal cases. This session prompted me to randomly pull a couple of my dockets to kind of get a context to discuss these topics here tonight. Obviously, this isn't a scientific study, but this is I think a good reflection of what we see on a day-to-day basis, not just myself, but my colleagues on the circuit bench. One of these dockets that I was able to draw was just from last week. This is a typical day. I think this is a reflection of what we see on a day-to-day basis. This particular morning, we had 15 cases before the court. They were all criminal cases. 3 of them were sentencings. 6 of them were revocation hearings in which individuals who've been placed on probation were back before the court. The Commonwealth had moved to revoke their probation and send them to the penitentiary. 4 of them were pretrial conferences. And there were 2 bond hearings that we also heard that particular morning. Of those 15 cases, 8 of the defendants who were before the court were African American. On another day that I pulled the docket for, there were 12 cases before the court. 10 of them were criminal. Of those 10 criminal cases, 6 of the defendants were African American. So on these 2 particular days, which again I believe are accurate reflections of what we see on a day-to-day basis, we have between 53 and 65% of the defendants that were before us were African American. Obviously, this is a disparity. When we look at the population here in Jefferson County, it's around 22% African American. So I'm going to come back to that in a second. I promise I'm not going to go beyond 5 minutes. But when I talk to groups about what we do and what types of things we do on a day-to-day basis, as I just discussed, we have bond hearings, everything from bond hearings, initial appearances, all the way up to sentences, when we have to make a decision as judges as to essentially what the punishment should be for an individual. When we're doing those sentencings, we are provided with a report by probation and parole, which is really a snapshot of who this individual before us is. It talks about how much education they have, what their criminal history is, what their family background is, if they have mental health issues, all of those types of things. When we make our decision, the primary things that we are supposed to consider, and this is statutorily outlined and mandated to us, are whether or not probation would unduly depreciate the seriousness of the offense that has them before us, whether or not they are best in need of treatment that can only be provided in an institutional setting, and what their risk to the community may be. Okay, those are the factors that we are to consider. Obviously, one of the factors the statute doesn't say is we're not supposed to consider their race. And that makes sense. You know, everybody talks about colorblind justice, blind justice, and we're not supposed to think about their race. However, I would opine on this topic that it's impossible, and we should, it's impossible not to, and we have to, in a way, consider them. If you are anybody who appreciates the context in which we all live, in which we have a history of institutional racism, which we have a history of structural racism, redlining, as was discussed earlier, all of those things impact why an individual may be before the court system. There are opportunities for education, there are opportunities for good health care, good housing. All of those are factors that we have to consider, and I am delighted to get a chance to have further discussion about those, because I think we all have to have, even if it's an uncomfortable discussion, a discussion about these topics so that we can try to reach some sort of solutions to help change that disparity. Thank you.
Good evening. My name is Tara Haggerty. I'm the Chief Judge of the 10 Family Court Judges here in Jefferson County. Judge Haney very eloquently expressed her gratitude for why we're here tonight and the eagerness that the judges have for listening and getting feedback on what we do, and I'd like to echo that on behalf of Family Court. And as Judge Edwards said very eloquently as well, I'd like to thank everyone who put this evening together and gave us the opportunity to be here. Like District and Circuit Court, Family Court has a wide variety of areas of law within our jurisdiction. I think that every area that we do in Family Court is important because they all obviously affect families. We do everything from divorce and custody actions to paternity and child support, to domestic violence and child abuse and neglect cases. I think everyone would agree that the most important thing that we do is our dependency docket, which are the child abuse and neglect dockets. There are 10 family court judges here in Jefferson County, as I said. I was shocked to learn this over 20 years ago when I got involved with practicing in family court, but there are enough child abuse and neglect cases in Jefferson County that each of the 10 judges devote a full day to doing only those cases. We also devote anywhere from a half day to a full day to our domestic violence docket. As every aspect of this community is struggling, Family Court, along with the other courts, is struggling with the opioid crisis. I and 5 other of my colleagues on Family Court were elected and took office in 2015. Since 2014, we're at an all-time high for child abuse and neglect petitions being filed in Jefferson County. In 2018, there were 2,460 petitions filed. The highest number before that had been 2014 at just over 2,300 petitions. And those are petitions as identified per family, not per child. So many of those represent a family, but there are multiple children included in those petitions. Everyone knows that this community has an opioid crisis. It's affecting everything. The National Council for Jewish Women did a Court Watch project about 3 years ago, and they observed family courts, dependency, neglect, and abuse dockets. They saw that so many of those cases are related to substance abuse that they initiated a recovery court project. And they raised the money for us to begin a recovery court to assist those families by providing added services and supervision in an effort to keep children in the home and not remove those children and place them in foster care. Kentucky is very high in the number of children in foster care. And I can tell you from my experience, the decision to remove a child from their parents or their family and place them in foster care is a heartbreaking decision. And it's especially heartbreaking because we really don't have the services that we need to preserve the family in the home. Last year, the federal government passed the Family First Act, which made billions of dollars available to states for in-home services to try to keep children who are active in family court or at risk of being active in family court in the home. And we are cooperating with our Cabinet for Health and Family Services to create proposals in order to get some of that money. We were told at a training a couple of weeks ago that Kentucky is one of the first states to get on board with that, and we do have the potential to get some significant funding for in-home services. So I'm very hopeful that that will affect our numbers as far as the number of children in foster care. Looks like I'm out of time, but I'm happy to discuss and take questions. I'm not really here to defend the status of our child welfare system. I think it's in crisis, and I would agree with that. But I can tell you that the family court judges care, and we care about making it better, and we're willing to cooperate and participate with anything to make that happen. Thank you.
Questions? Any questions? If not, or no follow-up? Oh, okay.
One, I heard Judge Edwards speak of the PSI, pre-sentence investigation reports, and Tara speak about recommendations of pre-trial makes to judges. And I'm curious, having written those pre-sentence investigation reports, there seems to have been something of a question about whether or not the writer of those reports should make recommendations to the judge or to the court. And I'm curious to know whether or not you welcome and would like for those persons, whether it's a pretrial worker in the jail or whether it's a probation parole officer doing the PSI, to make recommendations on that particular case.
We have such little information to go on when we're making. I greatly appreciate the pre-trial report or the pre-sentence report because it's critical. It gives us that snapshot. When it comes to those reports, though, I look at them more as an objective tool as opposed to looking at it for a subjective recommendation from the writer of the report. I'm going to get information. I'm going to get each side, because it's an adversarial process, is going to make their argument as to what their recommendation as to what I should do. And personally, I look at that report as the objective information regarding those factors that I would not know otherwise. Their educational background, the family background, those types of things. And I know it's difficult for me, obviously, to make those final decisions. And personally, I don't think I would need a recommendation. I just need that objective data and information to help me make that final decision.
Thank you.
Oh, one more question.
It's Kathy Hico again, and I just want to say thank you, Chief Justice Minton. This is such an important conversation, and I really appreciate that you have caused this to happen and that it will happen all across Kentucky. It caused me to look at the forcible entry and detainer warrant, which my organization just did a report on involuntary displacement. So I know that although we have 20% of the renter-occupied units in Jefferson County, we have 67% of the evictions filed. We have 54% of the judgments. So eviction, what happens in Jefferson, and you already heard 36% ownership rate for African Americans versus 70% ownership rate for whites. So that, and a 30% poverty rate for African Americans. And we have a map of where the evictions occur. So we know it's racial. We looked at the FED, and it is as if the Administrative Office of the Courts is acting as the attorney for the landlord, laying out every element of the case. I realize it's for judicial efficiency. What I don't see is an equal part of the complaint that gives as much instruction to the tenant on the elements of proving their case as you do in the FED. So we're working, I'm already started working to make some suggestions. So that's for the whole state. For Jefferson County, it has been 30 years since I practiced in eviction court, and it hasn't changed. And what is true is that not enough time has been allocated to treat people who do show up with the respect and ability to really offer a defense for their case. It would be an intrusion in the amount of time that you actually allocate if anybody really, if several people did. And I have, and other people have, seen judges go, it says here you didn't pay it. Didn't you pay it? And if the person goes, yes, but, I've heard, the judge say, that's a yes-no question. So that we really need to allow people to speak, and other places in Kentucky do that. And that means we need to allow that docket amount of time to expand so that people can be treated with respect and fairly and allowed to present. The other thing is that you can have an eviction case where the defendant shows up.
Okay, you got 1 minute. And
Okay. And there is no sworn testimony by the landlord. It's the lawyer who files it and signs it. It's the lawyer who comes in, and it's the judge who cross-examines the defendant to prove the case against them. You need to allow the defendant to cross-examine a person with actual knowledge if they show up in court. And you need to force that landlord to be there to present that evidence if a tenant says yes, but.
Okay, thank you, sir. Thank you. Our next group and last group. Randy White, the Department of Corrections. Daniel Fountain, Probation and Parole. And Lee Van Hoos, Chair of the Kentucky Parole Board. We start with Randy White, please.
Good afternoon, and thank you for having me. My name is Randy White. I'm the Deputy Commissioner of Adult Institutions within Kentucky. What I'm prepared to do is to provide to you, can everybody hear me okay? Yeah, in the back. I'm going to just give you a breakdown and an overview of adult institutions and a little bit about the Department of Corrections Probation and Parole. While I'm not getting into Dan's territory, I'm just going to provide some numbers and try to entertain some questions at the end of this session. I have spent 23 years within the Kentucky Department of Corrections after getting the Army GI Bill and going to college. And I wanted to make a difference, and I am too a proponent of mass incarceration. I would enjoy working myself out of business, but so far I haven't had any luck at that. But I keep working through all these years to strive for that. The Kentucky Department of Corrections is part of the Justice Cabinet, just as the Kentucky State Police, Juvenile Justice, and the Department of Public Advocacy. Currently, we have about 50,000 inmates on probation and parole status within Kentucky. We have over 12,000 inmates incarcerated in our 13 prisons, and out of the 13 prisons, one is a CoreCivic private facility. The others are state-run facilities, state-operated. In Kentucky, one unique thing about the Kentucky prison system is that we house, by statute authority, Class D and C inmates in county jails. So they're spread out across about 70 jails, 50 to 70 jails in Kentucky. So we have over 11,000 inmates in county jails incarcerated within the jails on felonies. Our racial breakdown currently is about 26% of our incarcerated offenders within state prisons are African American. 1% is classified as other, and about 73% are Caucasians. Within the Kentucky Department of Corrections, our organizational structure, we have a commissioner, 3 deputy commissioners, and those are adult institutions, which is me, community services and facilities, and a deputy commissioner of support services. We have 21 probation and parole districts that span 126 counties. And as I may have mentioned earlier, out of the 13 prisons, they span 10 different counties in Kentucky. We have about 3,800 staff positions within the Kentucky Department of Corrections. So we're a relatively small organization as far as, or maybe an average size organization. But I think if we're not the largest employer within the state of Kentucky, we're pretty close to it, behind the transportation cabinet. And we're not bragging on that. Again, I would love to work myself out of business if possible, but we've not been successful doing that today. Spanning the Department of Corrections, and I'll go down through our divisions, we have Personnel Division, Ombudsman Compliance, Medical, Mental Health, Correctional Industries, Operations and Programs, Substance Abuse, which is a paramount topic in Kentucky, Education, Reentry. And just to highlight reentry for a moment, about 2 years ago, we had about 12 to 13 reentry employees. I think now we're over maybe 50 to 70 employees within reentry, and it is its own division now. Communications, safety, the legislative office, probation and parole, local facilities, population management and classification, administrative services, parole and victim services, information services consisting of offender management and IT, and emergency management. Currently, 2 of our most significant challenges within the Kentucky Department of Corrections is retaining and attracting staff. We have about a 20% vacancy rate amongst the department. Unfortunately, whenever the economy improves and the unemployment rate goes down, our unemployment rate goes up and our vacancy rate goes up within the Kentucky Department of Corrections. One current initiative that we're looking at right now is substance abuse rebranding. Substance abuse originally started out as JDAC way back in the day, Jefferson County, Tennessee. But now that has spanned the whole department, so it's not only an adult institutions initiative. Our staff population breakdown right now is approximately 10% non-Caucasian, about 34% are female staff. We have 2 assessment centers within the Department of Corrections. One is at the Rotary Correctional Complex in LaGrange. The other is the Women's Prison in Shelby County, KCIW. Our job is to take what the sentencing courts provides to us in the form of felony conviction, and we carry out the sentencing and mandates of the court. Our paramount job is safety to the community, to enforce that sentence until the sentence is complete. Hopefully, within the time that we have the offender, we can hopefully address some of the behavioral, mental health concerns. Hopefully, we can turn that offender back out, because about 95% of our offenders are going to get out of prison and go back to the community. I've spent 23 years either enforcing rules or walking amongst those offenders and counseling with offenders as a caseworker, unit manager, and a coordinate 2 different facilities, including the Kentucky State Penitentiary for the last 6 years prior to becoming the Deputy Commissioner. So I'm an operations guy. I'll try to answer your questions the best I can when those come up. Thank you.
Since we have a smaller group, I get 2 minutes, right? I'm Dan Fountain. I work for the Division of Probation and Parole, and I really appreciate being part of this community forum because it truly takes a community to have successful outcomes for somebody being on probation and parole. About 10 years ago, our division went through a process to where we started using more evidence-based practices. And the research shows that, we have to make efforts in preparing the actual community to receive somebody who gets released from an institution. And if somebody has a sentence of imprisonment over their head and they're on probation, we have to tap into many of the community stakeholders to have successful outcomes. Fast forward to today, we created our own division of reentry, which deals with reintegration of somebody into the community. 99% of everybody in prison is probably going to get out someday. So it's evident for our staff to, prepare this person to have the resources to be successful. We deal with trying to mitigate circumstances as far as somebody's education, their status, their substance abuse status. We have evidence-based programming that we administer, which deal with MRT, anything that has to do with giving our clients the skill set to, obtain employment, be a productive citizen in the community. What I really enjoy is the fact that we are in a position to break down barriers and break down walls. Even within our division, we are really trying to alleviate the silo situation. We work with the judges, we work with local corrections, law enforcement, community agencies, even the faith-based community. When I first started this position as a probation officer, we were really not encouraged to mingle with anybody outside of our agency, but now it's opposite. Now what we do is we encourage community members to be a mentor to our population. We encourage our officers to tap into the faith-based community to assist us with our objectives. One of the greatest things that I've probably accomplished was back probably about 10 years ago. I was actually working with Reverend Lacey on a project in the Newburgh neighborhood where we would kind of engage in community service with our client base. And we had a session called a RING meeting, which was our reentry neighborhood group meeting. And what this meeting served as was a support group for our clients. But what I found is it was a support group for me also, because I obtained skills and really looking at our population as in, this could be me in this chair. So, I was right out there with the guys when we had community service projects. And what I do is I encourage my staff to be a part of the community and engage the community, because everybody under our watch is going to be in the community someday. And we want to give them the skills to be successful, to be safe. So really, the main goal that we have now is actually preparing the community for our justice involved, and treating them like people instead of treating them like a number. So I'm very excited about this initiative, and I hope to be I'm good. I hope to be invited back, because I really feel that, it really takes the whole community to engage this population and make them feel welcome. So, later on, they look at this period in their life and say, well, that chapter's over, but now, I learned something by being in the criminal justice system. I learned that, my only outcome wasn't not just to go to prison. If you give somebody the skills, our best thing that we can do for somebody is to get them out of our system. So I appreciate everybody, and I'll stick around for questions. We want to kind of talk about some of our success stories that we have as far as people in our system. But I really appreciate you all.
Good evening. I'm Lee Van Houston. I'm the chair of the Kentucky Parole Board. And as you read in your pamphlets, the Parole Board is the primary releasing authority for those convicted of felonies and sentenced to a term of incarceration with the Department of Corrections that includes not only the adults but the youthful offenders also. And along with just an eligibility hearings, which is the name of the hearing when we're deciding if someone will be released on parole. At that point, we're deciding if or when an individual will be appropriate for release to the community. Along with that, we also, if someone is paroled, we set conditions, what they need to do when they're on supervision that might enhance their ability to succeed on supervision. And then another large part of our duties is revocation hearings. Those are not only for those placed on parole, but also for individuals that are placed on supervision by law, those that are released on mandatory reentry supervision, those that are placed on sex offender conditional discharge. All of those cases, although not released by the board, if there is an incident where they violated the terms of their release, and probation and parole reports that to the parole board, they come before us as a revoking authority. Well, how do we make decisions? First of all, just to share a few numbers, there are 9 members of the parole board. We work in panels of 2, so that equates to 4 panels or 4. In a typical month, we'll see 1,700 cases. That's between revocations and parole eligibility cases. So it's quite a bit, of a workload that we work upon. As we look in how do you decide? Well, it's not flipping a coin. It's not, throwing darts. The way that we make decisions is very structured. We look at risk assessments. The parole board has its own validated risk assessment that tells us the risk and need, and what's the risk when they're released, what are their needs, what do they need so they can be successful. We also review the risk and needs assessment from the Department of Corrections and take into consideration all of that information. Further, Judge had mentioned earlier the precinct's investigation. That's an important part of what we review also. Within that, it's not only the elements of the crime that was committed, but also the criminal history, the social background, and any other educational background or mental health history that may be available to us at that time. Also, we look at have they been on probation or parole or any type of supervision before? How many times? How successful were they? We also review their criminal history, which is a part. We also take information from victims and letters of support from the community. We also take letters of concern and information from prosecutors and judges that they want to forward the information to us. Additionally, we also look at what they've done while they've been in custody, and that's a very vital part. We have the part that's all history, and that's never going to change, and we realize that. What we look for is change. So they can change, they can be a successful person in the community. So with that, we look at what programs have they had in the community. From that's where we relate back to what were their offenses, what was their criminal history, what does it tell us about what they need. Did they get into programs that address those needs that will make them successful when they come back out to the community? How did they do? Did they succeed in those programs? Were they thrown out of those programs? Additionally, how did they interact with authority? And did they have any disciplinary hearings while they were in? Were they serious? Were they minor? How did those really shape how they did while they were in custody? Those are all elements that we look at. And also, in addition to those elements, we also are part of the National Institute of Corrections, and they're the Association of Parole Authorities International, as well as the National Parole Resource Center, where only a number of states have been chosen to be part of an assessment group that's called the Structured Decision Making Framework. Kentucky was only the 5th board that was chosen out of the United States to be a part of this. So we were trained for a year, and that's another assessment tool that we look at and we use when we're deciding, is someone ready for release or are they not? Now, we partner a great deal with Probation and Parole and the Department of Corrections because they prepare them to see us, and that's the important part. So we regularly share with them the things that we see. Are we seeing a number of people that are not getting their programming? Are there other needs that they have that we think would be pertinent for Department of Corrections to partner with us? I'm just going to throw in real quick, we have partnered with the Division of Probation and Parole. There's a large issue with people absconding and returning on supervision just because they don't report. We worked with them and said if they have been absconded for only a short period of time, work with those individuals. Don't bring them back to the board. We'll be glad that you do what you can once you found them to help them get to the services they need and to stay in the community. So I would like to say with that, we came up with a program working with Probation and Parole where we rescind warrants for those individuals and then get them back on track. It started last year, and we rescinded 1,645 warrants last year. And today, this year, we've rescinded 575. So that's over 2,200 people that were able to remain in the community and not be returned to custody. Also, just throw in one more thing. This year, we were successful. We worked for 2 years in the legislature to pass a bill for a parole continuation sanction. This year, House Bill 189 was passed and signed by the governor. That gives the parole board the ability at a revocation hearing to put a person into a program, and when they complete that program, they're automatically released back to the community and don't have to come back before the board. It gives us the ability to put them in that treatment program, that substance abuse program that they failed on the outside and they keep using, so we know they need to do it on the inside. So we can put them in that program, and then they don't have to come see the board again. They immediately go back out, which is the best for them with their treatment. After they've had treatment, it's best that they return to the community and their support system immediately. So that is an initiative that we're very proud of, and certainly appreciate the support of the legislature and the governor to get that passed this year. I'd be glad to share any information I can. Sometimes I know it's looked on as a mystery of what we do, but we're always glad to share the evidence and the information of how we make our decisions.
My name's Sarah Wilburn. I'm an LCSW. I provide therapy in community mental behavioral health. And I specialize in working with trauma with children. And we address it all. Physical abuse, sexual abuse, community violence, impaired caregivers, domestic violence. Something that I come across, not infrequently, is children being re-traumatized by the process of going through the legal system. And I'm just curious, what has the legal system done to provide trauma-informed trainings for any of their frontline staff, for any of the personnel that shapes policies or influences policies and procedures? And an extension of that, what kind of supports are in place for vicarious trauma of any of the frontline staff that might come in contact with?
That's ma'am, I've got something for you. So the first person to ask the question gets a door prize, so. Well, that's an excellent question. I'm really happy to ask that. I was hoping someone would, because it's a highly technical question. And the question is about trauma with I guess, adolescents that started incarcerated. Recently, the question was concerning trauma and adolescents that, and maybe being trauma being furthered by the system of incarceration. In Kentucky, as is the case in most correctional systems, we do a pretty good job of locking up the offenders. We do a pretty good job of keeping the offenders inside the fence. We do a pretty decent job, but it's still short of where we want to be of mentally assessing the offenders whenever they come into the system. It's pretty much we do what we can and what we can afford because we're challenged with resources. But what we've identified in Kentucky in a project that we're currently working upon, we're currently trying to partner with the University of Spalding, and this is just in its beginning stages, but we had a collaboration meeting actually 2 weeks ago with Dr. Ida Dickey, if anybody is familiar with that, who is also in collaboration with the University of Louisville and the University of Kentucky. What we endeavor to do is to establish a system that we can behaviorally assess. We can assess and provide a full assessment to all 18 to 24-year-olds upon intake into the Kentucky Department of Corrections. Because we got to know what we have before we can provide treatment and maybe justify funding and ask for funding through the Justice Code. So what we endeavor to do is to try to get students on board to sustain a full assessment of behavioral needs for the inmates whenever they come into the prison. Now, I would love to do everybody, but we got to do what resources we can provide. Our beta group is 18 to 24-year-olds. So what we want to do is to provide a full assessment, and maybe that it'll take 6 or 8 hours, whatever will be required. And also in that collaboration with Spalding University of Louisville and the University of Kentucky, we want to know how to train our staff. Because believe me, when you stand at a cell front and you talk to a young man for 5 to 6 years, and you get the same story for 5 or 6 years, which I've done, and you ask mental health, what's wrong with this guy? And they say there's nothing wrong. It's behavior. It's a choice. Folks, when it becomes chronic, it's not a choice. We got to look at it as more than that. So I'm really glad you asked that question because we do have a project in the works. Now I'm told that there are some European models. Maybe Norway has looked at this. But I don't think anybody has ever really fully sealed the deal. So perhaps we can be leaders in this. So whenever Ida gets back into the country, and it is forensic psychology, perhaps we can get this kicked off. Because I want to know how to treat behavior as a chronic condition rather than a choice, because we're missing the mark in corrections. So I hope that answers your question. If you want to talk to me about it more offline, I'll be glad to do it.
And I can give some feedback around the juvenile side of things. The coordinated worker program has a responsibility that was required within the reform to be able to provide trauma-informed training to all of our staff. So we're able to now be able to utilize things like the ACE study, be able to understand adverse childhood experiences, be able to provide more connections and resources to families and kids. And so we've taken a much greater holistic approach than just looking at accountability and that piece. And trauma is the key to be able to do that. And then the second hat that I'll put on for just a quick second is the child welfare side. Our judges spoke about a lot of the work that they do, and we provide education to both the family and the district court judges around trauma-informed practices and what it means to understand the populations and the trauma that they've experienced. And that's something that as system people, we have to keep moving towards being not just trauma-informed, but being trauma-active and being trauma-engaged. And so that's a goal that the court has to take on to really make sure we make that movement.
Good evening. I think I can speak from here if everyone can hear me. I just want to say I appreciate coming here. I appreciate Representative Scott picking me up to make sure I made it. And I'm also sitting with Judy Jennings, who every weekend we're in the jail and the basement, and we are doing our activities with the youth there. And so these conversations about looking at the whole person, about accountability, we have to remember that these things impact the whole community, especially our children. And I appreciate you mentioning the adverse childhood experiences. I am a direct person who has dealt with that on many levels and continue to deal with that. And I know that it's not a death sentence. As well as these when people enter our court system, it's a snapshot into their life, as someone said. It's not the end of them. I work with the Bail Project. My name is Shamika Parrish-Wright. Thank you. And you can always go to bailproject.org. I can plug that if you need to refer someone or you need to learn more about what we do. But I got up to speak about, please, to encourage our judges to consider other options than cash bail, to consider more ORs and administrative releases, to also remind ourselves that not all failure to appears are on purpose. We've been here over a year doing this, and I know it's just been over 800 Louisvillians we've helped, but in that we've seen that a large percentage are people who are dealing with drug and alcohol abuse or related to that situation. A lot, the next bar graph, if I would say, would be people who have violated probation and parole, and so I was really encouraged to hear about the programs that are in place to rescind some of those things. And then the last part would be more the newer, low-level petty crimes and things like that. So those trends that you all are seeing, we see them as well as we're trying to help people out. We're in the front end of this thing. We're trying to, one, decrease the overcrowding, which we've been able to help do with, as Mr. Durham said, and two, as Leo Smith has mentioned a little bit, when we have people out pre-trial, we're giving them an opportunity to fight their case, and we're helping to create better outcomes. So I just want you to consider that people's situation and poverty and all these other isms are why people are often in front of you, and consider more options to help. Thank you.
Yeah, so my name is George Eklund, and first off, thank you for everybody for coming. I know that it's Thursday night, and I do applaud you all for at least starting these open and honest and uncomfortable conversations about how your all's offices are connected in setting up people to fail and allowing some people to succeed. We just have to realize and acknowledge, and I think a lot of people do in the space, that our bias and race is omnipresent, and we've all grown up in a very white-centric society that we have these deeply ingrained inequality beliefs. And I have bias, we all have biases, and so it's hard, it's uncomfortable. I'm glad that it's happening. I hope that it continues happening, and I hope that we all acknowledge that this is a never-ending conversation. We're all working for a justice system that is more open and sets people up for success, not locking people away. So I do have some calls to action for you all. One is expand this conversation. I would be really interested to see what it would look like to have this in a laundromat, or outside the grocery store, or just on the corner in the park while we have barbecue. I think that would be a really interesting, visceral experience for everybody. And then I think any way that we can open up the legal community. I've worked for lawyers, I love lawyers, but you all use a lot of jargon, and that creates these unintended gates that make people feel less than. So I think by thinking about our job descriptions that we're putting out, what are the preferences that we're inserting into our job descriptions, and how can we make it more open and encourage a wider swath of Jefferson County and Louisville and Kentucky to apply for those positions? I think we can go through our offices and try and figure out, okay, how can we use more human-centered language? How can we remember that people are more than the worst mistake that they just committed? And then just really dig in and look at your offices and say, okay, how can we create a culture of change? So, but I acknowledge your all's intent. I'm excited to be here, and I'm excited to be part of this.
Thank you.
I'm going to see if I can talk as loud as Shamika. Am I talking as loud as Shamika?
No.
Should have known. Oh, it's here. Hi, my name is Judy Jennings, and I direct the special project and we do art activities in the visitors lobby of the jail every weekend, as Shamika said. We've been doing it for 10 years, Reverend Lightsey and Dan. We were in those ring meetings. Those were wonderful. That was a great model. I wish that they would come back, the neighborhood support groups. They were very important. But I just wanted to urge everybody to take the long haul look, because children who have incarcerated people, that is an adverse childhood experience, that is a form of trauma for those children. And we talk about family cycles of incarceration. which we can see, but a lot of those are the family practices. The same families are being affected by the judicial system over and over, and you can see the outcome of that. So we really have to think about how we do things differently for the next generation. What's working now is not working now.
Just want to be sure that I'm Jim Peterson one more time. I want to be sure I get to address Ms. Van Hoos. We need so much more reform in the parole board system because, of course, with the amount of people in prison, that's one of the ways we can lessen the population, obviously. And you all oversee 20,000 cases a year. That's impossible with only 9 board members. I'm hoping that possibly they would add more board members at some point. Is there any chance of that? And them being all politically appointed is very unfortunate. You would hope it would be more scientific, sociologists, that kind of thing, but I know it's political. But I just don't know how you can look at a case file, not you, but board members. It's impossible, that many cases per day. Is there any discussion of that? I know in New York, they have passed a new law to increase their board members, and they have more board members than we do, and they have less cases. I just wondered.
There isn't any discussion at this time. That doesn't mean that it won't move forward. I want to be a little bit clearer. Now, an example, on a Thursday, there will be either between 60 to 120 revocation hearings on Thursdays. So that is a lot for that week. But the members work very hard, and they work long hours, and they work because they take it very seriously. And I know it appears in the political appointments, but the law determines who actually qualifies for the job. It's someone with 5 actual years experience in law, corrections, social work, sociology, had been a past board member for 5 years, medicine and education. And I've worked with individuals during my 6 years from just about every background. So it is political, and a political appointment, but it's a little less than you might think that it is, because there's also the Community Corrections Commission who reviews the information, reviews the applications, and then makes recommendations to the governor. So it's a little tighter than it's just whoever they want to pay off. Now, I'm not going to say wasn't something similar to that years ago. I say it's not your grandfather's parole board. I can say that because my grandfather was on the parole board. So it's a little tighter process, and just to share, members when they come on, they have at least 150 hours of training and observation. We're fortunate that we have an excellent relationship with the National Institute of Corrections. They then get to go to a 40-hour program with the National Institute of Corrections, and then they have mentors in this continual training.
How many staff members would you have? I mean, so a couple of board members were looking over individual files. Do they have staff members behind them that have already reviewed a lot of this thing, or is it just the board members that are looking at these?
Well, I will tell you the risk assessment. Well, first, the parole board is just that. Several years ago, they changed the structure. It used to be the Office of the Parole Board with a staff that worked for the parole board. They changed that structure, so the parole board is simply 9 individuals right now. The Department of Corrections by law is tasked with providing the parole board with all of the information they need. And actually, my Director of Parole Services is here with me, and it's her staff that gathers the information, completes the risk assessment tool, and gathers the pertinent information for the board. So we have our assessment, we can look at information, and we open and read, and I think she can attest. My members find mistakes where things are accidentally placed in different files routinely because they read everything so carefully. But her staff, Angela Tolley's staff, prepares everything for the board, so it's organized and we're ready. And luckily, Kentucky's Kentucky Offender Management System provides everything in front of us. It's not the old days of some big file and maybe something didn't get put in. Everything that's entered is entered or either scanned in to that system, so we have all the information before us on the computer and available to us.
Hi. Hello. Okay. Hi, my name is Julie Kalin, and since this is Court Talks, full disclosure, I am a local district court judge. I have a question for the parole board chair. You mentioned that the parole board is made up of people from all walks of life and it requires some experience. When you were describing that, it seemed to me that the type of experience you were describing would necessarily result in more law enforcement-oriented people being on the parole board. Do you know what the current makeup is with regards to prior experience of the board members, and is there any effort to equalize that?
Currently, with the 9 members for myself, I have 33 years in corrections justice system. I actually was the director of probation and parole when the reentry initiative started, and that was a passion of mine. And I'll be quite frankly, when I was contacted about the interest, that's why I was contacted, is because of my passion for reentry. Next, our most tenured member, who will be leaving us in about a year, is Caroline Mudd, and she has a background as a warden. Again, very offender-oriented. She wants to see people get out and be successful. She doesn't want them back because she worked as a caseworker too, and that's been her objective. Next, we have Larry Brock. He is a retired ATF agent and was the chief of police for the Richmond Police, and he has been with us several years. Next is Michael Bolkus, who also worked with me as assistant director of probation and parole and was a probation and parole officer. Again, very instrumental in reentry efforts, and that's why he was considered for the position. Also, we have Melissa Chandler. Melissa has spent her entire career working with the parole board. First as staff, I always kind of brag on her. She started, and she is education by training. She was in the education field, but she started and worked her way up from the bottom of the parole board staff all the way through till she had Miss Tolley's spot until she got the opportunity and was placed on the board. Additionally, we have Robert Powers, who is in clergy and ministry as well as an education background, and he was a volunteer chaplain for a while in the DOC system and came to the board. We have 3 new members that were just appointed in January, and first is Brenda Beers-Renicky, and she's from Northern Kentucky. She was in the business world for quite a bit of her time in the workforce, but then she switched over and went to law school, earned her law degree, and worked with Commonwealth Attorney Rob Samuels up in Northern Kentucky, with her emphasis being on the need and the promotion of getting help for the opioid addiction and seeing those cases through and seeing them into treatment. Next is Peggy Winiger, who's another one of our new members. She did have a background in probation and parole, but she also worked with children and families. I won't get the right letters for that, but she worked with children and families and did a lot with permanency and placement, so that's truly the biggest part of her background. And the last is Ladidra Jones, who has worked in a variety of positions, from education positions, working to help seal the gaps between race and make it see that all students are in a more equitable light for their education. She also most recently has worked as a substance abuse counselor within the system. So that's the variety of background. There's a balance. Yes, public safety is number 1, and then offender reentry is also the greatest decision. Those backgrounds help everyone understand. If you've worked with offenders, you understand the circumstances they're in. Also, if you've worked in education, medicine, sociology, social work, it helps give a varied background too. But those are by law right now, the backgrounds that are.
I suspect that voting by individual board members, that the board knows, I'm not saying that any are more biased than another, but I'm sure it's not public knowledge as to board member A, B, and C, vote at a different rate to allow people. They should be somewhat relatively the same because they're seeing all, relatively the same cases if they're not appointed to specific cases. that's all private. I doubt that the public knows what, if any, board members are high or low on an approval scale or denial of parole.
The Community Corrections Commission looks at that occasionally. That is available. And also, on any case, there's a record of the vote and the decision. And that's all in the records.
Okay. Thank you.
I would be remiss if I didn't speak to what has been pointed out as something of a universal problem between adult and juvenile justice systems, and that is diversity of employees. I'd like to hear something about what's being done to recruit and retain minorities within both the adult and the juvenile system. I came to work in the field because someone recruited me. I found out that there was an opening in probation and parole. So I went up and applied and got hired. I was retained principally because someone within the system mentored me and helped my development career-wise. George Wilson played that role. And so I'd like to know what's being done today to address this problem. If you have a facility in Lyon County, or Bell County, or Hardin County, or Dare County, it's difficult to staff, especially when the percentage of minorities in those facilities is so high. Can you speak to that, please?
If we can first have Patrick Carrington is with the Administrative Office of the Courts. He is our racial and ethnic diversity. I think here he comes. So we wanted to introduce Patrick and have him share the work that you're doing at the agency and your role within the Court of Justice.
Absolutely. Thank y'all for having me, guys. I really appreciate it. My name is Patrick Carrington. I'm the Diversity and Inclusion Coordinator at the Administrative Office of the Courts. What I'm charged with doing is recruiting more minority individuals for our workforce. I'm also charged with educating the workforce as well, training them on topics such as implicit bias and cultural awareness, so we have a better group to serve the population here in Kentucky. So that's just a little bit of what I do. There's much more, but I don't want to bore you all.
Thank you.
No problem.
All right. Judge, I'm going to ask you to come up and talk to us about the focus groups, and Chief, I'm going to ask you to just close us out. But I just want to say, yes, oh, do you have a question? Go ahead. Please.
This is not so much a question, but it is some comments. And first of all, to the Commissioner White, I want to say I commend you to start to look at some of your models, because we've seen what those have done in other countries, and a lot of the people are treated as human beings, and they come around being informed. Some of the suggestions I would have would be that I think good behavior should be rewarded to good inmates. And what I mean by this is that currently, if there's a fight in the yard or whatever, there's a lockdown that includes the honor dorm. Now, I think it'd be an incentive to be in the honor dorm and to have established good behavior if you're going to suffer the same consequences as those that are causing trouble. So, as it is now, if somebody messes up, everybody suffers, even those who have demonstrated good behavior. I think that placing inmates close to home is a good idea, because in transitioning, it's going to be the family that takes them in and helps them transition back into normal society. So right now, there's, it's the luck of the draw where you may go. And so I think that would help in transitioning people back into society. One thing that seems to be a pattern is that older inmates a lot of times get picked on. And so it might be a consideration to take a lot of them and put them in the same dorm, so they wouldn't be subjected to having their valuables TPDs, other possessions stolen, and not be able to defend themselves. You mentioned that you need more staff as the economy gets better. You have a hard time keeping things staffed. And, I would say that's definitely a case in that it's probably at a critical stage at a lot of prisons. And because of that, it's like where maybe if you had more staff, they step in and stop fights and things like that. A lot of them will not do that immediately, and they'll just stand back and let things materialize and happen because they're not armed, so they have fear of physically harm themselves. So obviously staffing up. This goes into the justice system. Kentucky is one of the states that sentences for sometimes for certain criteria 85% of the time. I think that's a mistake for several reasons. For one, if you're a young person going in and you've got a long sentence, and you know you're going to be in there for a long time, you don't have any incentive to be good, to take classes, to try to change, because you're in there for the long haul, and so you feel like if you want to get in trouble. So I was a part of the generation that I got drafted, went to Vietnam, and a lot of people I knew had a chip on their shoulder saying, well, what are they going to do? So Vietnam, I'm already here. Well, it's kind of the same thing. And what are you going to do? Put me in the hole where the holes are so overcrowded that you're not going to even be there 30 days because you're going to be pulled out and put back into the yard. So the other thing is if you're staying in there a long time, we as a public are paying more and more money for them to be incarcerated. And so if there's a chance for them to have their lives changed, and obviously I know there's a small percent that change, but again, those that do, at least we're not paying for them, they can be upper pro senior, they can earn good time because they take courses and substance abuse and behavior and all the other good things that could actually make an impact and make a change. And so I think that's important to consider. And so I think that is part of the justice system too, but I think that's something that not all states have that. And so I think that's okay. And then finally, there's got to be a crackdown on drugs in prison. I don't think this maybe is like anyone, but most of the drugs coming into prison are not being brought in by visitors. It's very, very hard, and they're coming in other ways, and you can figure that out. But again, it's definitely not. When you go through everything you got to go through to get in, you'd be very lucky to do anything. And because the drugs are plentiful, that's a cause of violence in prison, because now you've got the same thing that's on the streets. You've got fighting in the territory, who's distributing the drugs, and who owes who for the drugs, and all of that. And so it's not just an open epidemic out here, it's also for many inmates, the same thing in prison. So
Okay, thank you very much. Again, I got to tell you, this is unprecedented. As a journalist in this community for almost 40 years, telling my age, I've never seen the courts be so open and accessible. So, panelists, please hold on to your notes and your presentations, and Judge and Chief Justice, let's put our heads together to see how we can expand this and do this more and make this more accessible to more people. Okay, panelists, would you all be willing to do this again at some point? I know it's a lot to get you all together, but I mean, there may be a possibility where we can do you on camera, maybe do some videos and place them somewhere. We're going to talk about this. It's extremely important. I've never seen this. I want to thank you all for coming out as well. And Mike O'Connell, I think your point of the cathedral process that you mentioned, and just treating people like human beings. How can we make that a standard across the board, starting with the most powerful person in the justice system, which is the police officer? You know, how can we make that the standard? So, Judge, I know there's focus groups. The judge is going to talk to you about that, and Chief Justice is close us out. Thank you all very much for your attention and your interaction.
First, thank you again to all the participants, and thank you for being here. I also want to thank really Gene West. Gene not only moderated this, but actually helped push this on the publicity. And Reverend Lyson, to your point, our public information office did get the word out to the media, but you see. Okay, so in any event, the focus groups are going to be held all at the Urban League, and the evening focus groups are May 23rd on courtroom experience, June 6th on bail and incarceration, June 12th on eviction, and I bet, Kathy, you might have something to say about that, I was guessing, and Saturday, June 22nd on expungement. The evening sessions are from 5:30 to 7. The Saturday session is from 10 a.m. to 11:30. Reverend Wright.
Pastoral privilege. Thank you for your effort. I would accept the comment I heard earlier about our language as being at times a little professional and siloed. And as we head into the focus groups, I think that we need to pay attention to that. But even more so, the one thing I want to say is, you all got here somehow. It would not hurt for you to go home to your keyboard on your computer or wherever and send out 50 emails identifying the focus groups and what's going to happen. And thank you for having them at the Urban League in West Louisville.
We also thank the University of Louisville, Dr. Martin Schroeder, and the grad students, Bailey Collins, Courtney Lush, who they're compiling the data from the surveys. The surveys are still online, they're still available here. Please fill them out. And we're going to also use that information, and then they will be facilitating the focus groups.
Judge Clayton was a different benediction. I appreciate so much the rapt attention of everyone in the room, the participation of all of these folks who came and really exposed themselves to questions and were willing to answer the questions, and I appreciate that. This is not the end of the conversation. This is the beginning of the conversation, and obviously we wish this room had been full to overflowing. But I know that based on that challenge the Reverend has given us, you're going to leave this meeting, you're going to say, you know what, we started this conversation tonight, these focus groups are going to focus on matters of interest to this community. Please continue the conversation, and believe me, I'm willing to come back and do this again. Thank you very much. Good night.